Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of New Tech Promoters and Developers Private Limited versus State of UP and others, wherein the Honorable Supreme Court discussed about the constitutional validity of the Real Estate Regulation and Development Act 2016, in short, RERA. The court had framed 5 questions of law with respect to the constitutional validity of RERA. On the present show, we will be discussing the first question, that is concerned with the retrospective or retroactive applicability of RERA. The court had asked whether the Act of 2016 is retrospective or retroactive in its operation and what will be its legal consequence if tested on the anvil of the Constitution of India. In order to understand the answer to this question, let us go through the pertinent observations by the court. Firstly, the court differentiated between retrospectivity and retroactivity. According to the court, retrospective means looking backward, contemplating what is past, having reference to a statute or things existing before the statute in question. And a retrospective law means a law which looks backward or contemplates the past, one which is made to affect acts or facts occurring or rights occurring before it comes into force. In contrast, retroactive signifies characteristic or event which happened in the past or requisites which had been drawn from antecedent events. And retroactive statute means a statute which creates a new obligation on transactions or considerations or destroys or impairs vested rights. Further, a retroactive statute operates in futuro and its operation is based upon the character or status that arose earlier. Secondly, the court observed that merely because a legislation is made retroactive in its operation, it cannot be said to be violative of Articles 14 or 19(1)(g) of the Constitution of India. To the contrary, the Parliament indeed has the power to legislate, even retrospectively, to take into its fold the pre-existing contract and rights executed between the parties in the larger public interest. Thirdly, the court explained that the objects and the scheme of the RERA intend to promote effective consumer protection, uniformity and standardization of business practices and transactions in the real estate sector, to ensure greater accountability towards consumers, to overcome frauds and delays, and also the higher transaction costs. Fourthly, the court further elucidated that the scheme of RERA makes the registration of real estate projects mandatory, and even the projects that were commenced before coming into force of RERA will have to make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of the Act. Fifthly, the court clarified that the intention of the Parliament in enacting RERA was to bring within the fold of the statute the ongoing real estate projects, and its provisions in unequivocal terms apply to existing as well as upcoming projects. Thus, by way of necessary implication, the Parliament intended to include even those ongoing projects where completion certificate has not been issued under RERA. Sixthly, according to the court, the clear and unambiguous language of the statute is retroactive in operation, and by applying purposive interpretation rule of statutory construction, only one result is possible, that is, the legislature consciously enacted a retroactive statute to ensure that sale of plot, apartment, or building and real estate project is done in an efficient and transparent manner so that the interest of consumers in the real estate sector is protected by all means. And lastly, the court was of the view that even the terms of the agreement to sale or home buyer's agreement invariably indicates the intention of the developer that any subsequent legislation, rules and regulations, etc., issued by the competent authorities will be binding on the parties. Thus, such clauses ensure that subsequent legislations continue to apply on the ongoing projects, and it would be imprudent to say that contractual provisions will have an overriding effect on the retroactive applicability of the authorities under RERA. In light of the aforestated legal exposition, it was held that from the scheme of the RERA, it is manifest that its application is retroactive and not retrospective in character, and it can safely be observed that the projects already completed or to which the completion certificate has been granted are not under its fold, and therefore wasted or accrued rights, if any, in no manner are affected. Thus, I hope that it is clear that the RERA has retroactive applicability and not retrospective applicability. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.